Welcome back to The Deep Dive, where we take the most crucial global developments, the ones shaping tomorrow, and break them down into the essential insights you need to be seriously well-informed.
Today we're jumping into something that's, well, it's truly unprecedented.
We are undertaking a deep dive into what is arguably the most significant legal development of the decade. The 2025 advisory opinion from the International Court of Justice, the ICJ.
It really is. I mean, this is the highest judicial body in the world, the UN's top court, speaking with one voice on the existential crisis of our time, climate change.
And they are not holding back. The court's language right at the top, it's powerful.
It is. They called it an unprecedented challenge of civilizational proportions.
An existential problem of planetary proportions. I mean, that's not legalese. That's a declaration of a legal emergency. It feels like they're saying this is not a political debate anymore.
It's a legal reality, and that language is very calculated. It grounds everything that follows in this sense of urgency.
Okay, so before we get into the weeds, I want to be clear about something. This is an advisory opinion. What does that actually mean? It's not like a regular court ruling, right?
That's a crucial point. It's not legally binding in the same way a judgment between two warring states would be. But, you know, in the world of international law, an opinion from the ICJ,
It carries a ton of weight.
Immense moral and legal authority. It provides the definitive clarity on what states must already be doing under existing law. They're not making new rules. They're explaining the rules of the game as they already exist.
Got it. Okay, so let's unpack this monumental document. Our mission for this deep dive is to really get a grip on the two core questions the UN General Assembly asked the ICJ.
And they are pretty straightforward questions.
First, what are the obligations of states when it comes to climate protection? And second, what happens if they don't meet them? What are the legal consequences?
Exactly. We're looking at how the court wove together environmental law, the law of the sea, human rights law,
All of it.
into a single, comprehensive legal standard for climate action.
All right, part one. Let's lay the foundation. Before they could even answer those questions, the court had to deal with the procedural stuff. Did they even have the right to weigh in?
Right, jurisdiction and discretion. The jurisdiction part was pretty simple. The UN General Assembly asked them, and the UN Charter says they can. So, check.
The real fight was over discretion then. Should they do it?
That was the real test. Were there any compelling reasons to say no? And some states argued there were.
I can guess what they were. This is political dynamite. They were worried about judicial overreach, right?
That was the absolute central tension. The argument was, look, you're being asked to legislate, to make new environmental law. And that's the job of states and treaties, not courts.
It's a negotiation, not a declaration.
Exactly. And that this is all just too political. You know, it's about money, historical blame, things courts should stay away from.
That seems like a reasonable concern, to be honest.
Yeah.
So how did the ICJ get around that?
They were surgical. They were so careful to state, and I'm quoting here, that the court states the existing law and does not legislate.
So they built a wall around their own role. We're not inventors, we're interpreters.
Precisely. They said, we're just clarifying what's already in these treaties you've all signed. We're pointing out the legal requirements that are already in force. And with that, they just dismantled the overreach argument. No compelling reason to decline.
Wow. That decision alone is a huge signal. The ICJ is basically saying the tools to fix this legally already exist. We don't need to invent anything new.
Yes. And the reason they felt so confident proceeding is that they grounded the entire opinion in something beyond legal text.
But science.
The science. This is where it gets really interesting.
The scientific imperative, how did they handle that? Because that seems like a huge step for a court to lean so heavily on, scientific reports.
It's transformative. The court made a very conscious choice to rely explicitly on the IPCC reports, the Intergovernmental Panel on Climate Change. They flat out said these reports represent the best available science.
So what does that mean in legal terms?
It means the IPCC's conclusions are, for the purpose of international law, no longer just findings. They are treated as established authoritative facts.
So climate science is now, in the world's highest court, a legal fact, not a debate. So what are the key facts they adopted?
Okay, so there are three big ones that shape everything else. First, the physical evidence. Widespread, rapid changes have happened. Atmosphere, ocean, ice, biosphere, it's real, it's everywhere.
Okay, that establishes the threat. What about who's responsible?
Second, and this is the critical one, human activities have unequivocally caused global warming.
Unequivocally. No wiggle room in that word.
None. They cite the 1.1 degrees Celsius warming we've already seen. and they tie it directly to GHG emissions from fossil fuels and land use. This links state activity to global harm.
And the urgency. What's the timeline?
They adopted the IPCC's warning that we are more likely than not going to hit 1.5 degrees by 2040, even in the best-case scenario.
By 2040, that puts a ticking clock on every single legal obligation they define later.
It absolutely does. The law has to respond to the risk we know about now.
And when you talk about responsibility, you can't ignore the history of it.
Mm.
Did the court touch on that inequality?
Oh, they went right there. Using IPCC data, they pointed out that developed countries were responsible for 57% of cumulative CO2 emissions from 1850 to 2019.
57%.
And then they contrasted that with the least developed countries, the LDCs, their contribution, just 0.4%.
That is a staggering statistic. And it's not just a footnote, is it?
Not at all. It's the scientific and ethical foundation for the whole legal idea of common but differentiated responsibilities. It's the why behind the law.
Which brings us to the human cost, the ultimate reason for all of this.
Yes. The court accepted the IPCC figure. 3.3 to 3.6 billion people are highly vulnerable.
The billion, with a B.
And that vulnerability isn't abstract. It's increased death, sickness, food, and water insecurity. So by integrating these facts, the ICJ makes it clear. This isn't about protecting trees. It's about protecting human life from a scientifically verified massive threat.
Okay, so that sets the stage. Jurisdiction confirmed, science accepted as fact. An urgent, human-caused crisis with a clear historical imbalance. So now, part 2. What are the actual binding obligations for states under the treaties they've already signed?
Right. So the court starts with the big three, the UNFCCC, Kyoto, and the Paris Agreement. They see them as working together as a single system.
A progression.
Exactly. UNFCCC is the big picture framework. Kyoto had those specific targets for developed nations. And the Paris Agreement is the current universal rulebook that sets the specific goals for everyone.
And they don't interpret these treaties in a vacuum, right? There are guiding principles.
Yes, and they confirmed 4 key ones: sustainable development, equity, intergenerational equity, and the precautionary approach.
Let's pause on intergenerational equity. What does that actually mean in practice?
It means that a state can't just prioritize short-term economic gain if it means ruining the climate for future generations. It's a legal check on short-sightedness. Decisions made today must be justifiable to people living in 2100.
A heavy responsibility. Okay, let's zoom in on the Paris Agreement. What's the core legal standard for cutting emissions?
Right.
For mitigation?
The court confirmed that Paris sets the specific, quantified objective: hold the temperature increase to 1.5 degrees Celsius.
So 1.5 is not just a political hope or an aspiration.
No, it's now clarified as the legal benchmark. State actions have to be measured against that goal.
Okay, if that's the collective goal, how do individual states do their part? This is where the NDCs come in, the nationally determined contribution.
Exactly. The court confirmed that all parties have a binding procedural obligation to prepare and submit these NDCs every 5 years. So you have to do the paperwork. You have to show up.
But the big move, and I think this is where the court really tightened the screws, was defining the content of that paperwork. It's not just a blank check.
That's the huge finding. NDCs are not entirely discretionary. They're not just a policy wish list. The ICJ said they have to meet 2 crucial legal standards.
Okay, what's the first one?
First, they must represent a progression. It's a ratchet. Each new NDC has to be more ambitious than the last one. You are legally forbidden from backsliding.
So ambition can only go in one direction, up.
Mm.
What's the second standard? This is the tricky one.
The second is that the NDC must reflect the party's highest possible ambition, and the court interprets that phrase to mean that the plan must be capable of making an adequate contribution to hitting that collective 1.5-degree goal.
Whoa. Okay, let me see if I've got this. It means it's not enough for a country to just try its best.
Right.
If your plan, your highest possible ambition, when you add it up with everyone else's, still puts the world on a path to 2.5 degrees, then your plan is legally inadequate.
That is precisely the revolutionary shift. Ambition is now judged by its sufficiency to meet the global goal, not just by national effort. The focus moves from process to result.
So how do you make sure states actually do that?
The ICJ confirmed they have an obligation to pursue their domestic mitigation measures using a stringent due diligence standard.
Stringent due diligence. That sounds important. What does it look like in the real world?
Well, due diligence means you have to take all reasonable measures to prevent harm, but because the climate risk is so catastrophic, the standard is stringent.
So no token efforts.
No. It means you have to constantly check your policies against the latest science. For a big emitter, it could mean you have to, say, revoke subsidies for fossil fuels. You might have to ban new coal plants. It requires concrete, demonstrable measures that are actually capable of hitting your targets.
The rigor of the action has to match the severity of the threat.
Perfectly put. It's directly proportional to the scientifically established risk.
What about adapting to the changes that are already locked in? Is that a legal duty too?
Yes, absolutely. The court confirmed adaptation is a legally binding obligation. Parties have to engage in planning and implementation using their best efforts in line with the best available science.
So building seawalls, developing drought-resistant crops, early warning systems, that's not optional.
It's a requirement, and so is helping others do the same.
The money. Financial and technology support. This is always where the fights are.
And the ICJ was unequivocal. They pointed to Article 9 of the Paris Agreement, which says, developed states shall provide financial resources to developing states.
Shall, not should, not may. Shall.
Which, in law, means must. It's a binding obligation of conduct. So funding things like the Green Climate Fund or transferring adaptation tech, that's moved from being a political target that gets missed all the time
to a legal requirement.
It's a legal requirement. And if a developed nation fails to provide that support, they're not just breaking a promise, they're committing an internationally wrongful act.
Okay, so we've covered the treaties, but the court didn't stop there. Part 3, this is where they cast an even wider net, right, into customary international law.
This is a huge deal because customary law binds every single state on Earth, whether you sign the Paris Agreement or not. There's no opting out.
So what are these bedrock rules?
The ICJ confirmed 2 of them apply directly to the climate system. The first is the fundamental duty to prevent significant harm.
What does that entail?
It means every state has to act with due diligence to stop activities inside its borders. And this is key. This includes the actions of private companies from causing major harm to the climate system.
And how far does that duty reach?
Exceptionally far. Because the ICJ said this obligation is erga omnes.
Okay, stop there. Erga omnes. Break that down for us.
Of course. It's a Latin term. It means towards all. In this context, it means the duty to protect the climate isn't just owed to your next-door neighbor. It's owed to the entire international community.
So a breach of that duty is an injury to everyone.
It's an injury to all states.
So theoretically, a small, landlocked country in Africa could raise a legal claim against a massive emitter halfway across the world for failing to protect the shared global climate.
That's exactly the power of it. It gives every single state a legal interest in every other state's compliance. It establishes that the injury is truly global.
That is a massive shift in legal standing. And what specific actions did the court say this due diligence requires?
They made it very concrete. They said it requires states to conduct environmental impact assessments, or EIAs, for any proposed projects that are particularly significant emitters of greenhouse gases.
So you can't just greenlight a massive new oil field or a fleet of new power plants without first doing a specific science-based assessment of the climate damage it will cause.
Not if you want to comply with your customary law obligations. You have to internalize those climate costs at the project level, not just bury them in a national policy.
Okay, and what was the second customary law duty?
The mandatory duty to cooperate. The court said that given the global nature of this problem, cooperation isn't optional. It has to be sustained and continuous.
So no state can just say, we'll handle this on our own.
Exactly. They said discretion in how you cooperate can't be an excuse for not cooperating at all.
All right, let's pivot from general law to a very specific area.
Yeah.
The oceans. The law of the sea, or UNCLOS. How did the court connect greenhouse gas emissions to the sea?
This was a major clarification. The court found that GHG emissions constitute marine pollution under the definition in UNCLOS.
Wow. So carbon dioxide going into the air is legally the same as dumping sludge into the ocean.
In legal terms, yes. It's a substance introduced by humans that results in deleterious effects. That triggers a whole separate set of powerful obligations under the Law of the Sea Convention.
And what are those obligations?
A stringent due diligence obligation to protect and preserve the marine environment. States must take measures that are as far-reaching and efficacious as possible to stop the effects of climate change and, specifically, ocean acidification.
As far-reaching and efficacious as possible. That sounds even tougher than the Paris Agreement standard.
It can be. The court is saying that even if you're meeting your NDC under Paris, you could still be in breach of your NCLA obligations if you're not doing everything possible to stop ocean acidification. It's a complementary and potentially much stricter legal check.
And this section of the opinion also had some really important news for small island developing states, the SIDs.
A huge victory for them. Their biggest fear is that as sea levels rise, the coastlines they measure their economic zones from will retreat, and their territory will literally shrink on the map,
Taking their fishing rights and mineral rights with it.
But the ICJ put a stop to that. It found there is no obligation for states to update their maritime baselines once they've been properly lodged. Sea level rise cannot legally shrink your country's entitlements.
That provides incredible stability. So your exclusive economic zone is locked in.
It's locked in. And even more fundamentally, on the fear of losing statehood entirely if an island is submerged, the court noted that a complete loss of territory would not necessarily mean a loss of statehood. It's a huge legal reassurance.
Amazing. Okay, let's turn to the final pillar the court used, international human rights law.
And this might be the most powerful connection of all. The court made it plain. Protecting the environment is a precondition for enjoying human rights. You can't have one without the other.
Which specific rights are we talking about here?
The most fundamental ones, the right to life, the right to health, the right to an adequate standard of living, which includes food, water, and housing.
So let's make that concrete. If a state fails to prepare for climate-driven famine, it's not just a policy failure, it's a potential violation of the right to food.
Precisely. If it fails to build resilient housing and people are displaced by a superstorm, that could be a violation of the right to a home. The connection is direct. Climate failure is human rights failure.
And the court also weighed in on the right to a clean environment itself.
This was groundbreaking. They concluded that the right to a clean, healthy, and sustainable environment is inherent in the enjoyment of all those other rights. It's not a bonus right. It's an essential foundational component of a life with dignity.
So to put it all together, if a state fails to act on climate with stringent due diligence, it's not just breaking an environmental treaty. It is fundamentally failing to protect the most basic human rights of its people.
That is the legal hammer. And it gives citizens and activists a whole new avenue, using human rights courts and forums to challenge government inaction on climate.
Okay, that is a comprehensive list of obligations. Which brings us to part 4, the second big question. What's the price of failure? What happens when a state breaches these duties?
The answer is based on the foundational rules of state responsibility and international law. The core finding is simple: a breach of any of these obligations we've just discussed
To any source treaty, custom, UNCLOS, human rights.
constitutes an internationally wrongful act, and that automatically triggers the legal responsibility of that state.
The bar is set. But we keep coming back to the hardest part of climate law. Causation. How do you possibly link country X's emissions to country Y's specific harm, like a flood or a drought?
The court faced this head-on. They acknowledged it's difficult. It's not like a simple oil spill where you know exactly who's to blame. The harm is cumulative from many sources.
So how do they solve that legal puzzle?
They said that while the link is more tenuous, proving a causal connection is not impossible. They established a new legal standard for it:
And that is?
a sufficiently direct and certain causal nexus between the wrongful act and the injury.
Sufficiently direct and certain. What does that mean? It sounds like it opens the door for attribution science.
That's exactly the point. It allows a court or tribunal to look at the scientific evidence that can now estimate how much a specific country's historical emissions contributed to, say, the extra sea level rise that made a particular storm surge so destructive.
So you can assign proportional blame even if multiple countries are at fault.
You can. The ICJ is saying the law is sophisticated enough to handle that complexity.
Okay, so once the wrongful act and the causal link are established, what are the remedies? What must the responsible state actually do?
The law requires full reparation, which is broken down into 3 parts.
Let's take them one by one. What's the first?
First is the continuing duty of performance. Just because you're found to be in breach doesn't let you off the hook. You still have to perform the original obligation.
So if your NDC was found to be inadequate, you can't just pay a fine. You have to go back and submit a new adequate NDC.
Exactly. You have to fix the underlying failure. Second is cessation and guarantees. You have to stop the wrongful act.
What would that look like?
If the wrongful act is, for instance, providing massive subsidies for new fossil fuel projects, cessation means you have to revoke those subsidies immediately. And you might have to provide guarantees you won't do it again.
And the third and final part, the big one, full reparation.
Which itself has three components: restitution, compensation, and satisfaction.
Okay, restitution. How can you possibly restore the climate to how it was before?
You can't, not perfectly. But the court suggested restitution in this context could mean things like reconstructing infrastructure that was destroyed, or undertaking massive projects to restore damaged ecosystems like coral reefs or mangroves.
That could be astronomically expensive. What about compensation?
Compensation is for financially accessible damages, the economic losses, the costs of adaptation. And here, the court said something very important for climate cases.
Which is?
That where the exact dollar amount of the damage is uncertain, and how do you put a price on a lost species, a tribunal can award a global sum based on equitable considerations.
So they can look at what's fair.
Exactly. They look at the polluter's capacity to pay, the victim's vulnerability, and award a sum that's fair and just. Even if you can't itemize every single loss, it ensures there's a remedy even when the harm is complex.
And lastly, satisfaction.
That's for the non-material injury, the damage to a nation's dignity or sovereignty. It can be a formal apology, a public admission of wrongdoing, or, most importantly, the judicial declaration itself from the court saying what you did was wrong.
That declaration is a powerful tool in its own right.
A very powerful political and diplomatic hammer.
So this deep dive shows us that this ICJ opinion it's not just a recommendation. It's a complete legal blueprint.
It is. The big takeaway is that the ICJ has clearly defined climate protection not as a voluntary policy choice, but as a set of binding, stringent legal obligations that stretch across all areas of international law.
And it's laid the groundwork for holding states accountable, activating the full force of the rules on state responsibility.
The era of saying climate action is discretionary, that's over. The law now demands stringent due diligence, and the benchmark is its capacity to actually help meet the 1.5-degree goal.
And that standard is applied differently based on capacity and history.
Right. The court was so clear on this. Being a developing economy doesn't give you a free pass. But it does mean the standard of diligence changes with your capacity. As you get wealthier and more capable, the legal bar gets higher.
You're required to do more.
You are legally required to do more. They've linked historical wealth and current capacity directly to the stringency of the legal duty. You can't hide from an existential threat.
Which brings us to our final provocative question for you, the listener, to think about.
Given that the ICJ determined that a state's capacity determines how much it must do, and that its economic development is not an exemption, how might this ruling compel states that have historically profited the most from high emissions to reevaluate their current climate plans? How does it push them to move beyond just claiming their highest possible ambition to actually guaranteeing they make an adequate contribution to saving our collective goal of 1.5 degrees?
The law has now set the standard. The political action must follow. A question that will define the next generation of climate litigation and diplomacy. Thank you for joining us for the deep dive.
My pleasure.
We'll catch you next time for another exploration into the facts and insights that shape our world.